Howdy, 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 and thank you for joining me tonight on this September the 17th. We have a guest on tonight that I have really been looking forward to. We've all seen him on Aaron's channel. He is going to give us a lot of great information tonight. He is someone that I truly enjoy watching when he's on the different channels. He has his own channel now here on YouTube, your lawyer friend, Zac Morgan. And make sure you get over there, Goldie, if you could throw a link in there for it. There's also a link in the description for tonight's show. So you know how this goes. Before we get started, we got to bring in our old buddy from Clearwater. What's going on, Chad?
Thank you, Poe. We got the weather going on. We got a lot of work to do. Let's get right to work.
All right.
Temperature in Clearwater, Florida, Poe is 85 degrees. Partly cloudy, Poe. Precip is at 20. Wind is at 1. And it's 71% humid, Poe.
Excellent. Thank you, sir. Everything going good there?
Going good. Thanks, Poe.
All righty, sir. We'll be bringing Chad back in as we go. But as I said, my guest tonight is someone that I really enjoy listening to his content, seeing the different viewpoints that he brings into it. I saw him first with our old buddy Aaron Smith-Levin ever growing up at Scientology. I think he's an invaluable asset and someone that I've really been looking forward to having on here. So please welcome your lawyer friend, Zac Morgan.
Hey, everybody.
How's it going, Zac? Are we there?
It is. Weather's finally starting to turn to the benefit. It's just been a miserable summer.
Oh yeah, it's horrible here in Michigan. We're in the 40s, low 40s at night, and getting up into the 70s and 80s in the daytime. It's just mosquito weather all around for us. Now you're coming to us from Oklahoma. We've been having some technical difficulties going on here. Might be some connection delays that are going on, but we're going to muddle through it. And we're going to get things rolling. So can you hear me now, Zac? He's freezing up on us. He had to make some temporary accommodations. You guys know how it is. I have had to do that. I don't know how many times. Are you there now?
Good evening, everybody.
All right, we can hear you now. Can you hear me? Let's see. If he drops out, he'll come right back in. So basically what I wanted to do tonight is there's a lot of misconceptions and a lot of stereotypes about attorneys. And I don't want to just say, well, this is how I feel about it. I wanted to bring Zac in because Zac can give us the actual truth about it and how things work in the legal realm. So you got us now?
I can't tell where we are in the chat. If we're real time now, I got you.
Okay. I think we're real time now. So did you hear me talking about how I wanted to bring you in and everything? Yeah.
So
Excellent.
So I heard what you had to say. I heard it on a delay, but I think I'm caught up now.
Okay, excellent. A lot of people have some, it's just like with police. There's the joke that you can put either police or attorney in for where they see the cheetah eating his own excrement and they're like, why are you doing that? Why? Well, I just ate an attorney or I just ate a cop. I want to get the taste out of my mouth. And I don't think, a lot of people don't realize the significance of attorneys in our legal system. And I don't think that they really get the whole spectrum of it. So what is, okay, of course you had to go to college. How many years of college did you have to go through to get to the bar?
So I have 4 years of undergrad. I have a bachelor's degree in aviation, flew airplanes for a living, got a master's degree along the way, but that's the atypical path. For most people, it's 4 years of undergrad and then 3 years of law school. I did law school in 2.5 years. In hindsight, the sacrifice that my family, I was married, didn't have kids at the time, the sacrifice my family had to make and the stress of my marriage and the hindsight was not worth it. There's a reason it should take 3 years. Okay. It could be done in 2.5, but it was a really unhealthy lifestyle. Not nearly enough sleep, way too much coffee. I was not easy to get along with for the better part of 2 years. So really, if people are considering law school, take your time, spend 3 years. I think the cost is the same in the long run. the reality is you get to spend more time with your faculty and you get to spend more time working with the material, and it really creates a better product for your clients on the outside when you get out, I think.
Right. You're just in a boilerplate the whole time doing it that quickly.
Yeah.
That's yeah, and believe me, I can understand. I've been looking into it. I was actually thinking about going in and getting my degree and going for the bar, but by the time I'm done, I'll be well past 60 years old, and I think it's a little bit late to be jumping into the game. So
Now, and it's interesting you say that. I went to law school with the majority of them were what we call traditional students. So they,
Mhm.
we're in their early 20s. If you graduate college at 22, you're in law school at 22, 23, 24. I went into law school at 25, I think, 25 or 26. But I went to law school. One of my good friends to this day is a Marine. He's a former
Mhm.
Marine. He
Okay.
did. He earned his full retirement. So was that 20 or 25 years? Retired as a lieutenant at a large metropolitan police department, and then went to law school. And so he
Wow.
sort of had 3 careers, and he really brings it full circle. Sort of the theoretical and philosophical discussions we have.
Wow, that's awesome. Yeah, I think that someone like in my age range and with my life experience, I think that I can bring a lot of asset to it. Um, because we have a completely different outlook than a 22, 23-year old that's going into this kind of career field. So I think that that's one thing that is, I like it. I really look forward to it. I just worry about when I get, I'm like you, when I get into that study mode, I'm dead on with it. And, I've got 33 years of marriage and I've got my best friend. She's very understanding, but she put up with a ton of crap for 20 years with me as a police officer. So,
Yeah, it was interesting because I could tell those who'd made a car payment, those who'd had a mortgage payment, those who'd loved and lost, those who'd been hurt by life. And then you've got those who are coming in at 22 years old, just naive to life. They've
mhm,
been in the protected environment of college, and college should be a protected environment. It should
right.
let you learn within the bubble of safety that a university or college setting provides. But then people like the older folks I went to law school with, the non-traditional students, they brought a different perspective, because when you're dealing in hypotheticals and these made up fact scenarios by the law professors, in your head you're 18 years old or 22 years old, that doesn't happen, and then you see the 40-year-old goes, that's happened twice in the last 20 years to me.
Oh yeah, yeah, and that it's like some of the classes that I had went through, and it's exactly like you're talking about. They're going, well, this is hypothetical. This should never happen to you. Oh well, I just handled a case like that last month. What are you talking about? This shouldn't
Exactly.
happen. Yeah, so that's the nice thing about school, but it's also the bad thing about school is that it doesn't. Oftentimes they can't show you the true picture. I think Rodney Dangerfield, when he did that movie Back to School, and
Yeah.
here it is. He's a multimillionaire entrepreneur who, they're talking about all these things in business, what you have to do to get your permitting and all these things. And he's like, nah, you got to grease this palm, you got to grease that palm. And the guy's like, I think not. And he's like, that's half my budget every year is bribing people. So yeah, there's a lot to it. And a lot of professors spend so much time that they seem to be encapsulated themselves and they start to lose a lot of touch with the real scene. So that had to be pretty interesting. Now, what area did you specialize in?
So Oklahoma is, as a state, does not have boards of legal specialization. My
Oh,
neighboring
okay.
state to the south, Texas, does. So under Oklahoma law, if you're admitted to the bar, you can practice any area of law that Oklahoma recognizes, both state and
Oh,
federal law.
wow.
So you can defend traffic tickets, you can do bankruptcies,
Mhm.
you can do criminal defense,
Wow.
you can do medical malpractice, you can do workers' compensation. And there were several folks I went to law school with who had no desire to ever go to a courtroom. They
Mhm.
wanted to draft contracts. They wanted to be
Yep.
in-house counsel. They wanted to be risk managers for insurance companies, which requires the analytical process and the
Oh,
liability
yeah.
processing of the law. But the only time they ever wanted to be in a courtroom was when they raised their right hand to take the oath after passing the bar. That's the only
Wow.
time they ever wanted to be in a courtroom.
Yeah.
I am a litigator at heart, because if I don't have somebody to argue with, I argue with my wife. I know how expensive a divorce is. So if I don't have
Well, and the
somebody,
beating.
yeah, if I don't have somebody on the other side of the line from me, it's going to be kind of unpleasant from time to time. Um,
Yeah.
I enjoy litigating, whether it's in the criminal sphere or the civil sphere. The vast majority of my practice has been third party insurance originally, where I represented insurance companies when somebody was in an auto accident.
Oh, okay.
Then I went to the plaintiff side where I sued the guy who rear-ended my client. And then ultimately, most of my practice now is first party, where I sue an insurance company on behalf of the insured party for failure to pay benefits or undervaluing of a claim or a loss, things like that. I do some family law, not a ton. I do some guardianship work. I do some, I've done some divorces. I do a lot of wills and trusts. That it's hard to not get emotionally involved in that practice.
Right.
And lawyers should not get them. It's hard. I mean, there's going to be some emotional connection to it. It's hard not to. But it's in things like family law, criminal law, things like that, especially dealing with insurance companies, lawyers are key to making sure your rights are represented. And that's ultimately what lawyers do. Their job is to make sure that that their clients' rights are represented in whatever form or fashion that looks like.
And, hitting on that topic, there's been a lot, and I didn't want to make this about Scientology. I didn't want to make it, but it's an excellent example, is a lot of people talking about the possibilities of appeals on Danny Masterson. I honestly believe that we should be looking at a crap ton of appeals coming out of that.
Yeah,
And
absolutely.
folks are getting angry about the attorneys for Masterson and how that they're handling things. Can you explain about the attorneys, how it is part of your creed in presenting the best defense for your client?
Yeah. So everybody, every person, every human, and even a legal person like a business, but we'll exclude them for a variety of reasons at this point, has the right to fair representation. And I don't care if my client sits on the stand in front of the grand jury and says, "You're darn right, I did it. Here's photos of me do it. I'm going to do it again tomorrow."
Right.
The fact of the matter is, the right to a fair and cogent defense is a constitutional right. So, as a criminal defense attorney, I have friends tell me all the time. A friend of mine, she just moved to King County, Seattle, Washington, to be a public defender doing criminal defense. She said, "My job is to hold the government to account. If you did it, I'm going to make them prove you did it." Because even if you tell the jury you did it, but the jury finds you not guilty, that doesn't mean you didn't do it. It means the government didn't prove it. And the Constitution and the state laws are very clear. Federal laws are very clear that the government shall prove each and every required element of the crime beyond reasonable doubt. Anything lower than that, you walk out of the jailhouse with your keys in your wallet. That's what the law says. As a defense attorney, my job is to make sure that the government holds their burden.
And you when you take your oath, that's part of what you swear, isn't it? That you will do that.
Yeah.
And I think that all attorneys get a very bad rap for that without people understanding that that is your job, is that you must present that as best as you can for your client. And, they think about, I know a lot of people get upset over like the ambulance chasers, things like that. But you got to remember, those folks too are trying to make a living as well.
And one of the frustrations I have, like with the ambulance chasing thing, I find that term funny because it's true. I mean, the rules of ethics limit the way attorneys can market. There's a reason lawyers don't go door to door. It's against the rules for us to do that, and so it's a very regulated how we can market our services. Yeah. But the reality of it is, it gets a bad name because, like the McDonald's hot coffee case, everybody says, "Oh, they've all heard of it," but they don't know the actual case. That's sort of a day one of law school type case.
And a lot of them don't know the actual outcomes of it either.
Exactly. So they got this huge verdict. It was appealed, and they ultimately settled with this lady for an undisclosed amount of money. What people don't understand is, in that case, the coffee had been handed through the window. The grandson was driving grandma. They pulled into a parking spot and stopped so she could dress her coffee, put the cream and the sugar and whatever. That coffee was over 200 degrees. And when they stuck the coffee pots of all the surrounding fast food joints, the Burger Kings of the world and that sort of thing, they were all about 150 degrees. And McDonald's says, well, 200 is the coldest we can serve it. Well, there were reported logs of people reporting to the manager, this coffee is too hot, it burned me. And they failed to do anything about it. And ultimately, this lady spills 200 plus degree coffee onto her lap and had severe third-degree burns in her groin area.
And let me tell you, I personally, I can't tell you how many people I've seen with third-degree burns.
Yeah.
That is horrific. The damage that does, plus then you're talking about the infection that ensues after that. There's a lot that, But these aren't the things that we're hearing about. We're hearing about an old woman spilled a coffee in her lap, and the way I heard it, she was sitting in the restaurant when it happened. I didn't know she was in a car, but looking into it more, it was hard to find anything other than the splash headlines, the clickbait stuff.
Yeah.
When I finally found out that it had actually been lowered when they went to appeals and all that, but I didn't know 200-degree coffee. I mean, that's absolutely. I smoke meat as a professional barbecue person at between 185 and 200 degrees. I mean, that's above what I use to actually smoke meat.
Yeah.
Think the damage that could do to the body is ridiculous.
Well, I mean, I remind people water at sea level boils at 212 degrees. It's basically boiling water in a cup.
Yeah.
Is what they handed her. I wouldn't turn my kids loose with boiling macaroni water. I'm not going to turn my grandmother loose with boiling macaroni water. And that's essentially what they did to her.
And I actually was called to a scene where a pressure cooker had exploded. And the guy was halfway across the room when that boiling water hit him. And the 3rd-degree burns were, to this day, it haunts me in my dreams, seeing that. So, now that we know more of it and how this came about, we understand, partially about that verdict and how everything happened in the first place. I mean, she definitely deserved pretty good sum of money. I don't know how much she settled out for, but she deserved to be taken care of.
Yeah, I had I call it my baby lawyer face. Technically, in Oklahoma, a young lawyer has nothing to do with age and everything to do with the first 10 years of your status as a lawyer. Oklahoma has what's called a licensed legal intern program, and it is a limited license to practice under somebody else's bar admission, sort of like an intern doctor.
Yeah,
right? They're treating patients, but they don't have their own medical license, so they're doing it under the attending certification or something. And so I had the opportunity to learn from a couple of really good, really seasoned lawyers while I was in law school. I worked mornings at the law firm, went to class in the afternoon, and then on Fridays I took depositions. So I got to go to the courthouse to see judges every day from 9 to noon.
Oh, that's awesome.
And it was in the workers' compensation setting where we're not arguing about causation. We're arguing, right? If you get hurt on the job, you're just entitled to benefits. That's just the way it works.
Right.
We're not arguing about causation. Anybody can argue causation. I learned how to depose doctors. I learned how to read medical records. I learned how to talk with, high maintenance clients. I learned how to interface with my support staff. I learned how to talk to other attorneys. They don't tell you in law school that the person on the other side of the phone is a human.
Right.
They're the bad guy. You got to go beat the bad guy. The reality of it is there are people just jerks in practice, but most lawyers are really outstanding, just stand-up citizens, and they're fun to talk to. Hey, how are the kids? Hey, how was golf yesterday? Saw you at church last week. How was your vacation? They're just reasonable people with a job to do. And so once you understand that they're humans, we can accomplish a lot more through a telephone call than we can through a lot of times going to the courthouse.
Yes. And that's another thing. A lot of people don't understand that out of all the cases that actually make it to trial, many are settled long before it would ever get to that route. And there's good seasoned attorneys who should be able to work those things out. And they, all we see is the actual courtroom cases and things like that. And they just don't understand that there's a ton of work that goes into it long before you hit the courthouse.
Yeah. And going back to what you mentioned earlier about the Danny Masterson case, I've heard people say, well, how could you possibly cross-examine Jane Doe that way? Well, one, if you don't, you risk getting disbarred.
Yeah.
If you don't, you're not doing your job, period.
And
the ABA's model rules of professional conduct, most states have adopted a version of that. The preamble to it says the lawyer has a duty to represent zealously each and every interest of their client. That doesn't mean you only get to pick the fun ones. It doesn't mean you only get to argue the sexy points. You have to do your job with every witness in the box, whether they're good witness, bad witness, whether you like them or not. You have a job to do, and if you don't, you risk getting disciplined as an attorney.
And that's another thing that folks don't understand is that I think first off, what most everybody thinks is they see these multi-million-dollar law firms because that's who we see advertised everywhere, and then they see what's on television. And they're so jaded in their viewpoint of attorneys. I've got to say that myself, when I started in law enforcement and I was going in and I was, going in front of these attorneys, And I'd come out and I was just so angry. And then the judge, we had a great judge. He called me in his office. He goes, "Hey, look." And he started explaining everything to me. And he says, "When you're done with this case and everything's settled, it doesn't matter if you win or lose. They're still a human being. They just have a job to do, and they have an obligation to do it this way." Once I started looking at it that way, I no longer was I angry about decisions. I was, the way I looked at it was, if I didn't win, most of the time it was either because I didn't do something right or the jury just didn't, and sometimes it was the judge. The judge just, didn't feel that it matched the consequences of the crime. So, once I stopped letting it be personal, it made it a lot easier. And I started becoming friends with quite a few attorneys from that point.
Well,
So,
and I refer people, if you haven't seen it, go watch the movie The Lincoln Lawyer, Matthew McConaughey. I haven't seen the Netflix series, but I know it's based on a book.
Yeah.
But he's in a position where he knows his client did it, but he has to represent his client. He has to create reasonable doubt, so he's able to find a way to do that. Now, the way he does that isn't maybe a stand-up as perhaps we would like, but he had a job to do. And he found a way to get the job done. He hired private investigators. He has support staff. He has friends, in this case, an ex-wife who's in the prosecutor's office. He knows the detectives, and that's super real, whether you're in a big county like LA County or you're in some of the smaller counties in Oklahoma that have a total population of 12 or 15,000 for the entire county. Very small, out in Western Oklahoma, there's more cows and wheat stalks than humans for miles.
Yeah.
And you go to some of those counties, it's very much the same, whether I'm in Oklahoma City or I'm way out in, Godibo or, Mountain View, Oklahoma or somewhere. It's the same. I'm going to know the police officers. I'm going to know the lawyers. I'm going to know the judges. I'm going to know the court clerk, the court clerk's office staff. I'm going to know the local newspaper man. Right. If you want to find something out in a small town, go to the newspaper office.
Oh yeah. Or the church.
The church, the newspaper office, or the gas station. If you go one of those three places, they know everything that you need to know, and then you go find the people that they're talking about.
And I have an excellent example. I worked in Metro Detroit suburb for the majority of my career. That's where I retired out from first. And then I went to work for the Detroit Police Department from there. And Wayne County is the home of Detroit, Michigan. Mm-hmm. So in Wayne County, if I wanted to see the prosecutor, I would have to call, schedule an appointment, get there, go through all the metal detectors, all that stuff. And then if the attorney I was going to talk to was available, they would come and let me in, and I'd have to go directly to their office. I came working down here in Monroe County, and I could literally walk up to the prosecutor's office right now. They'll buzz me in. I go in and see whoever I want to see. Just a completely different world. We knew everybody in the Monroe County prosecutor's office, but yet in the Wayne County prosecutor's office, I knew maybe 3 attorneys that worked in that office. All the rest of them, if they weren't handling my cases, we had no idea who they were.
Yeah. In Oklahoma County, for example, they divide the cases up by the last digit of the case number. Is it odd or is it even? If it's even, this attorney staff has it. If it's odd, this attorney staff has it. So you can look and say, oh, all the cases today are odd numbered cases. So I know I'm going to have attorney X.
Now, do you have many? I know in Northern Michigan, we have it where they have basically the public defenders will represent 2 or 3 counties at a time because they just don't have enough to represent. They don't have enough to handle the caseload, and they have to spread it out over 2 or 3 counties. They don't have enough people to go out there and handle it all. Do you have those kinds of setups in Oklahoma? So
in Oklahoma, only 2 counties are large enough from a funding standpoint to have a dedicated public defender's office. Mm-hmm. It's the Oklahoma County Public Defender and the Tulsa County Public Defender, which Oklahoma City and Tulsa, Oklahoma, the 2 largest municipalities. The rest of them are handled on what's called the OIDS, Oklahoma Indigent Defense System. Is a legislatively created body that receives a line item appropriation from the legislature, and it's an administrative office that goes out for bid, and they take a lowest bidder type request for proposal, request for quote from local law firms and local attorneys specific to that.
That's awesome.
Yeah. So, and then, I worked for an attorney one time. We didn't do much criminal. It was primarily civil, but he had what's called the conflict counsel contract. So if the local attorney who had the contract for the public defender contract had a conflict with a client, my boss, the attorney I worked with would get the assignment.
Oh, that's wild.
but only on a conflict
Right.
type basis.
And I see like I think you see it a lot with you know who Jeff Middleton is, Judge Middleton.
Yeah, I'm a huge Judge Middleton fan.
Same here.
I
I
haven't
love
met
that
him, but
guy.
I would love to go to Michigan for no other reason than to meet him.
Yeah, he's pretty cool. And I didn't realize he was a big YouTube star when I met him a few years back. You know, I just thought, you know, he's just a judge with a ponytail. And then I started seeing him on YouTube and I'm like, this guy is awesome. You know, that there's a lot of interesting characters that are judges, that's for sure. But I see in some areas where the public defenders are actually on like a I don't know a contractor basis where they're actually, you know, they'll call them and say, hey, we have these cases to a law firm that's willing to do the public defender stuff. And they'll be, yeah, if we've got the attorney's presence, we'll go ahead and do it. Do you see a lot of that?
So ours is kind of a hybrid. Outside the big counties, they'll do the same thing. Like once a year, the OIDS contract. Like once a year, you can look at all the publications. They'll say we are accepting bids. Here's the bid packet or the bid information. We're accepting bids for all the counties. Go. And so in a small town, you've only got one. You've got it's a one horse town with one stoplight that flashes at night. We don't have a lot of competition. You get out to Comanche County, Lawton, Oklahoma. That's on a contract, but you may have 5 or 6 law firms. One law firm says, "Hey, I'll give you a really good deal, but I'm only taking nonviolent misdemeanors."
Yeah.
Somebody says, "I'm going to charge you a higher rate, but I'm only going to take felony homicide cases."
Wow.
And so they'll even split the contract up. In a small county, you get the bids. You get everybody from Otis in the drunk tank to the serial killer who's got bodies in the basement.
Yeah,
and everybody in between. In fact, you of course are an age to remember the Murrah bombing in Oklahoma City, and
Timothy McVeigh, I believe.
Yeah, exactly. In fact, to this day, still the largest act of domestic terrorism in the United States. The terrorism until 9/11, it was the largest act of terror in the United States, and still the largest act of domestic terror in the United States.
Yeah.
So Tim McVeigh was tried and given the death penalty at the federal level.
Yep.
His co-conspirator, Terry Nichols, was tried at the federal level and given life without parole. So the state of Oklahoma tried him because there were also state citizens who were not federal employees who were killed. So now it's state jurisdiction as well. The state said, we want our pound of flesh, and we want to get him for the death penalty. And it was tried in McAllister, Oklahoma, which is 3 hours away from where the bombing occurred. And the attorney who was assigned that case is last year's president of the Bar Association, Brian Hermanson. He was a one-man show in northern Oklahoma, part-time paralegal, and he gets a call from the Supreme Court. One of the justices says, "We want you to take this case and be his public defender. This is too big. We can't go out for a contract. It's too big to give to, the regular contract holder. This is a unique thing." And he said, okay. He finally takes the case, and one day he gets a call from Michael Tiger, who was Nichols' federal defense attorney for the federal case. And he was on the faculty at the University of Texas at Austin School of Law, which is a top 5 law school in the country, like a Harvard or a Columbia.
Wow.
And he calls and says, "Hey, do you want all of my file material?" He says, "Yeah, absolutely. Send it to me." So the FedEx guy shows up, or UPS, whoever, and I forget the exact story, but something like, "I have a delivery for Brian Hermanson." He goes, "Who's it from?" "Well, it's from Mike Tiger." "Oh, great. I've cleared the conference room." He goes, "You don't understand. I got two 53-foot trailer loads full of bankers boxes out in the driveway." They had to go. So he went to the Supreme Court and said, "I need help.
Yeah.
I need money. I need bodies. I need space." He rented a warehouse and hired a dozen maybe law clerks just to organize the files.
Oh yeah.
Just to start reading papers.
It's amazing when you start looking into, just for me as a law enforcement officer, the detective handling the case, the cardboard file boxes that you see all over the place.
Mm-hmm.
Some of my cases would have 3 or 4 of those, and that's just on my end of it. And then when you'd see the prosecutor and how many more they had over top of that, it was astounding. So yeah. I can understand. What was it? The gentleman from who ran through the crowd at the Christmas parade.
Oh, yeah, in Waukesha County, Wisconsin.
Yep.
Daryl, whatever his name was.
Daryl Brooks.
Yeah,
I mean, and you could see in the trial footage, you could see him literally stacking the boxes stacked up on the table and on the floor. How much of that was his insanity that he was piling in there, but it gives folks an idea of the kind of paperwork that goes into this.
Yeah.
And I don't think folks also realize that it's a hurry up and wait game with these. You file, then you've got to wait till you're given a date or you're given the okay, or if you have to have a hearing before you go forward with anything else. And then you're given the date, you have to wait for it, and then boom, everything happens unless there's a recess or something else that's going to clog it up for a little bit. But it's a tedious process. You really have to be into the litigation to want to do this.
Yeah, absolutely. And it's one of those too that a lot of something that the folks need to understand. If it's a small, like I had a 5 or 6 day jury trial, which by civil standards is a fairly long jury trial. And I didn't have a ton of exhibits. It was mainly testimony. It wasn't a ton of exhibits, but I had a dolly full, a dolly and a half full, a couple of trips to the courthouse full was all. I've seen cases and been involved in cases in which the courtroom where the judge, the jury, and the witnesses are is like room 1. They have attached ante rooms and conference rooms full of paralegals with printers, computers, file systems, and they're just churning documents.
And it's amazing. And like you were talking about the different levels, I've got just right down the road from me, it's about 1/8 of a mile from my house. There's a gentleman that has been an attorney for probably 30 years now. He only does real estate contracts. That's all he does. He doesn't go to court or anything like that. And he used to come to our restaurant that we had, and he would have stacks of papers, and he's just going through them. I come over, sit down, and he could hold a full conversation while going through all of it. And I'm just like, dude. And he goes, "Oh no, I love this. This is what I live for." So yeah, it's pretty interesting, the wide spectrum of the world of attorneys and the different kinds of specialties you can get into.
Well, that's one of the reasons I ended up sort of the backhanded way getting onto YouTube was I enjoyed following people and then got involved helping somebody with a channel because I was asked lawyer questions, and it sort of exercised the litigator part of my brain that I don't get to do anymore.
You ever worry about when you're doing the YouTube channels, people coming at you over the fact of your possibly advice or things like that? Do you ever worry about those?
So in theory, but I try to make it very clear, and I give a disclaimer. When I talk about the law, I'm giving general tendencies. So I've gotten questions quite a bit, and my normal answer is, generally the law is X, but you need to consult a licensed attorney in your jurisdiction because I don't know where you live, and I likely am not admitted where you live. But also I remind people, and this is true even to the folks hanging out with us tonight. If you have not signed a letter from me or from my office detailing the scope and nature of my representation, as well as detailing with specificity the fee agreement, is it hourly? Is it a flat fee? Is it a contingency? Do you have to pay a retainer I bill against, or is it going to be payable, paid as incurred? If you don't have, and my engagement letter is about 5 pages. So if you don't have that, if I haven't signed it and you haven't signed it and my office hasn't communicated with you, I don't represent you. So if you go to court and say, my attorney is Zac Morgan, the judge is going to call me and say, how come you're not here? I'm going to say, Judge, I have no idea what you're talking about. And I've searched my records. I don't represent this person. I never have.
Yeah, you hear that a lot on my channel where I will say, this is my opinion. This is, I'm not giving legal advice. And it's for the exact same reason is laws change. They change daily. I'm retired now as a law enforcement officer, and I honestly couldn't give you opinion on anything more than my opinion on anything. And I don't want to even try to broach that realm. I get emails all the time, people asking me legal questions, and I tell them you need to talk to an attorney or you need to talk to the police, because I can't answer that for you. And exactly. Like with you, my specialty is the state of Michigan and the laws of the state of Michigan. So anything outside that realm, it's purely going to be speculation or opinion on my part.
Yeah, absolutely. And I want to tell folks too, when you hire an attorney, most attorneys will give you a free initial consult. Not all of them. There's some areas of law in which it's just so complicated. It's hard to do a free initial consult. I'm going to have to do a huge document review. I got to get compensated for that time. By and large, most attorneys will give you a free initial consult. Here's the legal issues that I see. Here's the way we resolve those. Here's your chances of success. And here's what it's going to cost. Okay. Those conversations, even if you don't hire that attorney, those conversations are protected by the attorney-client privilege. So they can't go to the bar, get drunk, and start spilling your secrets. If they do, they're subject to attorney discipline.
Okay.
But also, that attorney interviewing you is your opportunity to find out, listen, you may be F. Lee Bailey, but you may not be the best fit for me.
Right.
Right. You may be the biggest lawyer with the fanciest office and the darkest wood walls, but you may not be the best fit for me. Right.
And that's
So, yeah. So use that interview, that time with the lawyer to find out, is this the best fit for me? And is this the best fit for my case? If you tell me no, listen, it's not really something I can do right now. I don't take it personally. I know that I have billing obligations I have to fulfill. There's staff who depend on me in generating cases. So,
and and I've one question I got to ask, and hopefully you might have an answer for, is what is up with the hair on a lot of these attorneys? You'll see these folks coming in the $10,000 three-piece suit, looking like they're going to meet with the president or something, but when it gets to their hair, it looks like Albert Einstein's brother. Yeah.
So I think I resemble that remark a little bit. There's a reason that I tend to wear the hat, and it's just to sort of keep it all out of the way. So, I tell the partners in my firm, we've got 4 equity shareholders in my firm. 2 are bald. 1 has long hair, like down to his shoulders. And the other one has a really thick Minnesota accent. So between the 4 of them, they've got the spectrum covered. I think it's sort of the same concept as Einstein. We spend so much time worried about our cases that we forget about the tangential things, right? And fortunately, the beauty of a suit is all the pieces are on the same hanger. So you just keep putting clothes on until the hanger's empty. Now you're ready to walk out the door. That's the beauty of a suit. Instead of piecing things together, I put everything on till the hanger's empty, and then it's time for work.
I've got a friend that's an attorney, and you see this guy, and you haven't seen mafia bosses wear as nice suits as this guy's got the Rolex on. He's to the nines. And then I'm like, dude, what is up with your hair? I ain't got time to worry about that. So I'm like, you put on $30,000 worth of clothes and accessories, and okay. So, but yeah, I understand it.
Yeah.
I'll get in those points where I'm really looking into something, researching things, or I'm working on the laser or the CNC, and I'm trying to figure something out, and I look like a complete bum. I look like I haven't washed in days. My hair is just all matted down. So I can understand that. You get so caught up in what you're doing, and it's got to be a passion for you to, the whole aspect of it.
Yeah.
We had an officer that, while he was working for us, he went through school and got his passed the bar and became a licensed attorney in Michigan. And he and I were talking about it, and the fact of, he could start a civil case, and it could be 2 to 3 years before that case actually hits the courtroom and they get a decision on it.
Yeah.
And he said, you have to love litigation to go into this.
Yeah.
Nothing happens overnight with any of it. So
yeah. So there's parts of litigation I love. I love going to court. I love standing at the bench and arguing. There's nothing that gets me as excited as walking into a courtroom with a deposition in my hand, knowing I'm getting ready to cross-examine a witness who lied on their deposition.
Right. That's awesome.
It just gives me, I'm like, oh boy, somebody's going to get their head cut off today, and I'm not Henry VIII, but I can sure play him on TV. Right. That's sort of the way
a switch. There's going to be a whooping.
Exactly. But then there's parts of it that are awful. Like, as a baby lawyer, boy, taking depositions is fun, and it's necessary. That's how we learn to examine witnesses. You can ask a really terrible deposition question to get away with it because there's no judge. You just catch an objection, and then the judge quashes it later. But it teaches you how to be efficient. Like, I'm billing my client $250 an hour to sit in this deposition and ask 6 hours worth of questions.
Wow.
Right. I have I have a moral obligation not to waste their time and money.
Yep.
Now, that doesn't mean, I will also tell you, folks, if you're ever subject to a deposition, you're going to be asked yes or no questions. Please do the attorneys in the room a favor. Your attorney and the attorney asking you the questions, just answer them yes or no. If you feel like you're getting put in a box, your attorney knows how to clean that up. I tell my clients all the time, answer the question. I don't care if you like the question. If it's a terrible answer, my job is to fix it, and I know how to do it. If I ask, what color is the sky? Or if I ask you, is the sky blue? And you say, I had waffles for breakfast. Great. That wasn't my question. Let me ask it again. I will keep repeating myself until you answer it.
I learned early on, our city attorney was basically a mentor to me. He was great guy, passed away just recently. But I remember the first time I was in a deposition and he said, can we have a moment? Took me out in the hallway and started knocking on my forehead like this. He goes, answer the question, only the question. I don't want to hear anything else out of you. You got it? Okay. And after that, we went and sat down and had we had something to eat. We were talking. He goes, look, you're not helping anything out by trying to expand on the question. Just answer yes or no. And he went through the whole thing. So I understand completely what you're talking about with that. And I found that depositions went a whole lot quicker the more I kept my mouth shut and just answered as was needed. So
I also tell people, unless it's, and even if it's a trial deposition to a point, but generally speaking, a deposition is a discovery tool, not a trial tool. I said, you're going to hear a lot of questions today and you're going to ask, why is that any of your freaking business? And the answer is it's not. But the discovery coach says they get to ask the question anyway. And my job is to tell the judge later they're not allowed to ask it. They're probably going to admit, yeah, we're not going to ask that at trial. That's improper. But they're going to ask it anyway. They're going to ask you all kinds of invasive questions about your personal life that you find highly offensive. And I don't care if you're on your moral high horse. You better get down and answer the deadgum question.
Right.
We can deal with this later. You may feel absolutely embarrassed when you get back in your car, but everybody does. You're not alone. It's the nature of depositions. It's just the way
that's the job of the attorney to ask those questions. I think now you'll be able to answer it better, but I think it answers a lot of questions for them. It tells them how easily that you can be irritated and broken out of your mold. It lets them know that you're the kind of person who you have to tell every life story about every question that's asked, and that you're probably going to put out way more information than your attorney wants you to. So it's not only the discovery of any actual evidence, but you're also learning about that person you're going to be questioning and what might be some real sticking problems with them. So
yeah, absolutely. In my notes, most of the time, so I can sort of remember most of the answers to the questions, but there's going to be a transcript that comes in to me, either e-tran or a paper transcript later. I'm not worried about that. I can read that later. My notes are your body language, your behavior, your irritability. Do you need a bathroom break every 15 minutes, right? Looking at your medical records, and what I saw in your medical records squaring with what your personality is presenting to me, right? It's the affect, right? Does the affect match the situation? Are you quick to anger? Those are all, I'll go back to the client, the insurance company, whoever, and say, hey, listen, we need to take this to trial because this guy's just going to shoot himself in the foot over and over again, and we can watch him, slowly bleed to death with BB holes.
Right.
Or listen, this guy is a rock star. I used that. I took a deposition. I represented an old lady. She was number 2 in line. Imagine like 5 cars and driving straight down a freeway. There's 4 lanes. The lane closest to the median is the number 1, 2, 3, 4. All these cars in the number 4 lane. The number 1 vehicle has a ladder fall off the van into the lane of traffic.
Oh.
The number 2 vehicle stops. My lady's in number 3. She stops. Then she's hit from behind by 2 pickups.
Yeah.
Fractures her back, has a bunch of surgery, lots of medical bills. So we sue. I sue everybody. I sue the driver of the van, the driver of the guys of the truck. I sue the bakery across the street. Anybody who saw it gets a subpoena, right? That's how we do it.
Yeah.
Then I dismiss him as I go. Well, I take the deposition of this old man. He's 82 years old. He reminds me a lot of my late grandfather, who passed right around the time I passed the bar exam. And he reminded me so much of my late grandfather. His testimony was just, I said, a jury's going to like him. A jury's going to believe him. So I called his lawyer and said, give me a nominal amount of settlement money and I will dismiss you today.
Yeah.
I got the client to approve. I settled it. I settled that aspect of it for some nominal amount of money. But, it was far less than the insurance policy. So it basically didn't affect the premium. I called this guy as a friendly witness at trial. Had I not taken his deposition, he would have whooped my butt at trial. But because I made him a friendly witness, the jury can't get mad at him. And I just told my lady, I'm just not going to ask you the questions that have a different answer than his, because that's my discretion as the attorney.
There you go.
We're going to go with his tale of events because it matches better.
Oh yeah. And I used to get upset when they would when I would see like the city settle out cases. And I'd be like, why did you give that person that money? And they go, look, we gave them $5,000 as an example. It's a whole lot cheaper to give them that $5,000, shut them up and send them on their way than to spend $25,000 to $100,000 fighting this in court.
Mhm.
So, and that's something that I think a lot of people don't realize also is settlements. Oftentimes it's much more financially effective for the person who's being sued if they can settle it out quickly and cut
Yeah.
out 90% of the cost they're going to have to go with.
That's absolutely true. And if for the business owners out there, think about it. There are just some accounts that you just write off as uncollectible.
Right.
You write them off. You write them out of your accounts payable list or accounts receivable list, and then you claim it on your income taxes, as a deductible expense because it was an uncollectible bad debt. You move on with your life. Could you have collected it? Absolutely. You were going to pay me or somebody like me a percentage of everything you collected plus interest. And by the way, they're dirt poor, straight broke, and have nothing to their name. And so 30%
Yeah.
of nothing is still nothing.
Yeah.
So
And
you just write it off and you move on. It's sometimes the cost of doing business. We call those nuisance suits or nuisance settlements.
what have you dealt much with sovereign citizens or their like?
So I'm very familiar with the movement. I've studied the movement. I find the movement fascinating because I wish I was as strong in my faith as they are in their belief as a sovereign citizen.
Jeez.
But it is the weirdest, most eclectic group of individuals. If for whatever reason, it actually manages to bring together the evangelical and the atheist. It brings together the black and the white. It brings together the
Oh,
rich
yeah.
and the poor. It brings together the conservative and the liberal. But they're all wrong.
Mhm.
Well, I wasn't driving, I was traveling. Cool. Well, in the state of Michigan, you still have to have a license to travel. I need your traveler's
Mhm.
license, please. I don't. Cool.
Yeah.
You're gonna get in my car and you're gonna get a free one-way ticket to
Oh,
Three
yeah.
Hots Cot. Would you care to
Yeah.
join me by consent, or do I need to pull out my less lethal and wrestle you into the car? Either way, this ends the same way for you.
Yeah, and I've personally dealt with sovereign citizens, and I as with you, absolutely amazed at their beliefs. They um, putting that sign out the window that I need you to read this, and my response is sorry, I refuse to enter into any contractual agreement with you, and I'm not going to go any further with that. You just need to give me your information while I'm traveling. And I'll break it off for a minute and start talking to them and ask them about their vehicle. How does it drive? Oh, it drives great. Well, how do you know? You don't drive, you travel.
Yeah.
And I just do things like that to catch them up. And almost always it ends up with busted windows and hurt feelings on their part. And then they get in front of a judge and the judge just blisters them with it. And, that talking about Jeffrey Middleton, we see a lot of that coming through his courtroom.
Yeah.
And if you're not up to date on things, I mean, some of their arguments can sound pretty valid.
Yeah.
So I can understand why a lot of people are sucked into that world so easily.
Yeah, and judges, to their credit, at least in most jurisdictions, including the ones which I've admitted, judges have continuing education just like lawyers do.
Mhm.
We call it the judicial conference is generally what they call it. But
Yeah.
at the end of the day, at least in my jurisdictions, all the judges are also lawyers, and they have to be.
Yeah.
So you go to
Well,
the Bar Association annual meeting. You go to the solo and small firm conference. You're likely to run into lawyers there or judges there. Like, what in the world is this Oklahoma County District Court judge doing down here at the solo small firm conference where everybody here has less than 5 employees in the firm? And then
right.
you realize, oh, this judge is on the landlord tenant docket. This judge is on the forcible entry and detainer, right? The eviction docket. This judge has small claims. And he's down here, getting up to date on the recent changes of the law, just like we are, because
Oh,
I'm
yeah.
going to represent somebody in front of him on this new law, and I need him to know this new law as well as I know it.
Now, do you have with the attorney associations or the bar associations in here in Michigan? The state police send out almost daily legal updates on changes to law, court verdicts that can affect things that are going on. Do you have a system like that in place that you use, or do you use the
So,
conferences?
we have a 12-hour mandatory CLE requirement annually, 2 hours of which must be ethics. Which is not, and we fortunately have gone to allowing them all online. At one point, you had to have at least half of them face to face; the other half could
Wow.
come online. But they now allow them all online. So Oklahoma is unique. We have OSCN.net. It's a public government website, the Oklahoma State Courts Network, and it is similar to Pacer in the federal system, but it's free. Everybody can look up every state court case
Oh, yeah.
for free. All the statutes, they can do all that for free. There are some individuals like Steve Bose puts out a product called the Bose Report, and it is a monthly report of every
I've heard of that.
reported jury trial in
Wow.
Oklahoma, whether it's federal court or state court. It'll list the parties, it'll list the lawyers, the judge, the witnesses, the experts, the verdict. It'll list it all. So you can look and go, hey, and you can sort by category. I want to see everything that was in front of Judge X,
That's
or I want to
crazy.
look at every car wreck case.
Yeah.
Right. Because, for example, Oklahoma is a fairly conservative state with our jury verdicts. It's also conservative politically, but this isn't a political discussion. But the jury verdicts tend to be fairly conservative. And so when somebody calls and says, how much is my case worth? And I said, well, right now, I don't know. But I will tell you that statistically, a jury will return a verdict of 1.8 to 2.1 times the reasonable and necessary medical expenses.
Wow.
And so when you look at the settlements are generally between 1.5 and 2.5 times the value of the reasonable and necessary medical. The fight is always over. You had $70,000 of medical in a fender bender that cost $800 to fix your car.
Mm-hmm.
How much of that is pre-existing? How much of that did you take? And they lean the medical, so they bill it at street value and expect you to negotiate 35% off of it like an insurance company. That's a big part of the medical, or the sort of the ambulance chasing fight in Oklahoma. But, I can tell people, I said, I don't know. I can't give you a dollar amount because I haven't looked at your medical records. I can look at a medical record and say, no jury's going to give this to you. I know you feel like it's super important. No jury is going to give you 15 rounds of epidural steroid injections when the first 14 didn't work. At some point, they're going to say, after 3 rounds, they didn't work. Stop incurring the expense. They'll give you 3. They're not going to give you 15. We figure out what your reasonable and necessary are. We calculate 1.8 to 2.1. Oh, by the way, you want me to settle for 2.1? Don't be a dick at deposition.
Wow.
Be a friendly witness, cooperate, come across as kind, come across as believable. I can maybe get you even 2.2, 2.3. If you show up looking like The Rock and you're claiming that your back hurts, but you're a bodybuilder, I'm not going to get you half of your incurred.
Yeah, it's I mean, it's but that's the amazing thing is you can sit there and tell people, don't show up looking like this, don't show up doing this, don't say this. They'll show right up and do it. And
I've talked to a bankruptcy lawyer friend of mine at the creditors hearing on assets. This goober shows up and he files bankruptcy, which is a valid pleading. If you can't, you're either illiquid or you're so strained on cash flow that you can't satisfy obligations, you qualify for bankruptcy relief. He shows up in a custom tailored suit with a Jaguar in the parking lot, gold rings and a Rolex. And so the bankruptcy trustee said, I'm going to have the bailiff bring you a manila envelope, place all your jewelry in it.
wow.
Get out your wallet, take all the cash out of your wallet, put it in there. Oh, that bank statement. Cool. I'm going to get a court order that says I now have control over that bank, bank account. So if you have, the jewelry would ultimately be discoverable anyway, but do yourself a favor. Don't show up with every piece of gold you've ever purchased on your fingers when you're claiming you can't pay your bills.
That's
some common sense.
that's always, it's dumbfounded me how people know that their attorney tells them, don't do this. This is going to work against you. They do it anyway. They just don't care. They know better than everybody. It's like the pro se people. I know what I need to know, and I don't need an attorney to tell me. And it's ridiculous. Now, one of the things that a lot of people notice about attorneys is the ability to debate or argue. What kind of training do you guys go through in law school for that?
Sorry, I'm bouncing the table and the camera's bouncing.
Oh, sorry.
That'll make everybody in the background sick over there.
I do it all the time.
So I think that's a fair question. So every law student in America has to participate in what's called the 1L moot court competition. So we divide our law school years into 1L year, 2L year, 3L year. That's medical students do the same thing. First year med school, second year med school, third year residency year, whatever. So 1L is your first year, 2L, second, third year, 3L, so on and so forth. Every first year law student has to take a full year, hours in the fall, hours in the spring, of legal research and writing. And about a third of the class is how to actually find the law. Once you understand how to do that, it's fairly simple. 2/3 of the class is learning how to write. You would be amazed how bad writers are when they get to law school. And for most of us, especially if you want to practice in federal court, 80% of your advocacy is done with the pen. Only 20% of it is done with the tongue.
Okay.
In federal court. In Oklahoma State Court, it's maybe 50-50 or 60-40, but it's still, if I have a really bad argument on paper, I don't care how great a debater I am, I can't fix it. Right. Yep. So we spend about a third of the class learning how to research and cite. And then we spend 2/3 of the class learning how to articulate our argument first in writing, and then our writing skills improve. Then we write an appellate brief, just like they give you case facts, and then you write an appeal, an appellate brief, and then you get in teams of 2 generally, and you go against your classmates before a panel of professors and upper division law students, and you argue the merits of your case and answer questions. And then we have so everybody has to do that, so they at least know how to present their case at argument.
Right.
If you've ever been to, and you've been to jury trials, you've seen this. They start with, the state call, it's time, will now give their opening statement. Thank you, Your Honor. May it please the court and members of the jury. That's just the way,
Right.
It's time for closing argument. May it please the court. The judge nods his head when we're off and running. It's just an acknowledgement of the court. You go before the United States Supreme Court. Good morning, Mr. Chief Justice, and may it please the court. It's just the way we start. So they teach you the decorum, and then then you get into the argument. So everybody has a baseline knowledge of that at the end of their first year. Then there are electives. So I took trial practice as an elective course. And the culmination, the final for that course was they took high school students from Oklahoma City Public Schools, and then we picked a jury from them.
Oh, wow.
And we presented our case, and then they deliberated. They retired for lunch to deliberate, and then they came back with a verdict.
That's awesome.
And we had moot court. I had the opportunity. It was one of the greatest experiences of my life, where I went to law school, partnered with the University of Central Oklahoma, which has a master's degree in forensic science. They took the law students and they partnered them with the graduate students in forensic science. So the forensic scientists had to learn how to communicate their discipline to non-scientists. And we as the lawyers learned the science and learned how to examine the witnesses. So tool mark examiners, right? Those are the people who match up the ridges and bullets.
Right.
Blood spatter experts, DNA, digital. I found digital forensics fascinating. If you delete it, it's not gone forever. If I pay somebody enough money, the software can rebuild it. So for the young people out there, if you don't want somebody to find it, don't create the thing. It will never disappear forever. It can always be recreated.
If you put it on the internet, it's out there forever. You can be found. So
in fact, there's a resource we were taught to use in law school. If I go back, I can go back and see what was on a website using a specific website that goes back in time and looks at every snapshot a website's ever had.
Oh yeah, there's several of them out there. I've used them myself to go back and find old websites, things like that. Yeah. And that brings up an interesting point. There are a number of cases that I was actually able to show the defendant was lying simply off of their social media photographs that they were putting out there. Tell me how that feels as an attorney seeing that happen.
So unfortunately, one of the questions I have to ask a lot in family law is I need to know what particular information you disclosed to your significant other while they were your significant other. Because as long as you are both of age, it's not illegal. But if you want it clawed back, I need a court order that says they have to delete it. And then I need a mechanism that holds them accountable to make sure they, in fact, deleted it. That is a really awkward conversation to have with another grown person that you don't know very well. Right. I'm about to severely invade your personal life, but I need to know what exists. If you tell me up front, I can solve it. If you lie about it and I find out about it later, we're going to have problems.
Yeah, I had one that was a homicide case, and the defendant kept saying from the start, "I've never held a gun in my life. I don't know what you're talking about. I couldn't have done this. I've never held a gun. I don't know how they work." I had several fake Facebook pages, and I was able to friend this person through the Facebook, through that one of my fake pages. And without even asking any questions, talking to them, just going through their photographs, I pulled up no less than 30 photographs of this person holding handguns in the pictures on Facebook. And it just completely, the prosecutor said that was probably the final straw that broke it. Was he sat there and lied and perjured himself.
Yeah, see, this is where the Alec Murdaugh trial in the low country of South Carolina, right? He ended up addicted to drugs. His kid was an alcoholic, and by any definition, he and his wife were enablers of their child, at least their youngest son, Paul Jr., or Paul, whatever his name was. They were enablers of his behavior. So let me make this very clear to the viewers: if you knowingly or complicitly allow your underage child to consume alcohol, you're breaking the law. And in most jurisdictions, that's a felony. I don't care if you think, well, it's safer if they do it at my house. It's still a felony. If you get caught, you should go to prison. That's my opinion as a father. And having seen what alcohol does to families, right? I mean, how many wrecks have you worked? How many people have you put in jail because they chose to consume alcohol and get behind the wheel of a vehicle and either could have but didn't, or did in fact injure or kill somebody, right? But his attorneys, man, they had a heck of a battle they had to fight. But I think one of their missteps, and it's not grounds, I don't think, for reversal and appeal, because it's trial strategy. Trial strategy doesn't inherently mean that you had bad counsel. Attorneys make errors in judgment every day, right? I should have called this guy. I should not have called her. I should not have asked that question. I should have asked that question. We do it all the time. The mistake was they allowed the seed to be laid that Alec Murdaugh was going to deny that it was his voice down at the kennels. They had put that forth in some written argument earlier in the litigation. That wasn't him. That's not me. I think he even maybe told the prosecutors that wasn't me in the video, whatever it was. And then he has to get on the stand and say, yeah, it was me, but I didn't do it. I was at the kennels, but then I left, because 57 people had said, I've known Alec my whole life. This is a particular, if you listen to his voice, it's a very particular tone of voice. Everybody would recognize that tone of voice. I would recognize it if I heard it tomorrow, right? Even though I've never met the man. I would recognize the tone of voice. Yep, I've known Alec for 30 years. That's his voice. His law partners, his best friends, his family is saying, yep, that's Alec's voice. They did, in my opinion, didn't do a great job of getting out ahead of that. In their opening statement, what they should have said is, the prosecution's going to tell you, but I don't care what they tell you. That's absolutely Alec Murdaugh's voice. He came down to check on his family. He was simply telling them, hey, I'm going to go and see my mom and dad. I'll be back in a few minutes. And during the period of time in which he was gone, this awful thing happened. They should have gotten out in front of it, and they didn't. That's a strategy error, but it's not reversible error.
Right.
Bad lawyer. It's not bad lawyering. It's just bad judgment. Yeah. They put on a great case. They put on the best case that they possibly could have, in my opinion. They represented and advocated for him very, very well, which is good, because he probably paid a lot of money for that advocacy, but they advocated really well for him. But I feel like that was a strategic misstep. They should have gotten out in front of that the very first sentence after, thank you, Your Honor. Good morning, ladies and gentlemen of the jury. My name is, and I represent Alec Murdaugh. This is what you're going to hear at the kennels. That is absolutely Alec Murdaugh's voice, but here's why it doesn't matter. They didn't do that, and I think that was a fatal error on their part.
Yeah, it may be fatal for him, period. So is he looking at a death sentence there? Or
so he's been sentenced. I don't think he got the death. He's been sentenced, but I think it's life without parole.
Okay.
But because of the nature of his crime and the fact that he's fairly high profile, there's probably going to be some special accommodations given to him in prison. It's maybe a little more difficult to keep him safe. And to be honest, he has absolutely no street smarts, and he has no street cred from the perspective of who's, if you're gangbanging and living life in the streets, even if you don't know anybody, when you get to the pen, you know how to navigate that community.
Oh yeah. And
he's not going to know how to do that.
Well, he's lived, from what I understand, a very privileged life. So,
yeah.
It's crazy. One thing I wanted to ask about, what are the fears in the legal community with the growing AI movement?
So this actually is, because I work in higher ed full time. This is also posing an issue for us in higher education. A graduate student at my institution who had crossed the stage as a graduate with a master's degree with honors, because final grades were not in yet. During the grading of his final written paper, one of his professors identified a section that says, I am an artificial intelligence robot. My database has not been updated since 2019 for more. Not only did he cheat, he didn't even read what he cheated on. Yeah. Another lawyer, one of our adjunct faculty members in the aviation department, in the aviation management division, wrote an article for like sort of the bar journal, the lawyer publication, not a full-blown law review article, but just a smaller article about artificial intelligence, and cites a case where the lawyer is facing lawyer discipline because he didn't give himself adequate time to submit the brief. He just basically he procrastinated till he was out of time. He told ChatGPT or some other AI engine, write an argument, write a motion for summary judgment or whatever it was. And it actually made up case law. It made up Smith versus Jones in a full citation to a case that doesn't exist.
Yeah, and that was something I was going to ask about. I'd heard about the case where an attorney presented evidence, and they found that the case law that they were trying to use was all made up by the AI system itself. So, but one of the things that's also worrying me about it is I just saw a video of what appeared to be Morgan Freeman talking, and it was very clean. It looked like it was actually him, sounded like him, and it was all completely AI.
Yeah, deep
And
fake. In fact,
yeah,
I saw on I can't remember if I was on Instagram or Facebook or something cruising, or maybe even a YouTube ad. There is an AI project that will now read you your textbooks in
wow,
Snoop Dogg's voice.
I can go for that. Yeah,
I'll let Snoop Dogg read me the top fold of the Journal Record all day long. That doesn't bother me at
yeah.
all.
That would
But
definitely bump that up for me.
yeah,
Goodness.
it used to be a living. People like, there's voice actors who do impressions as stand-up comedians, and that's
Right.
how they pay their bills. AI is now doing that artificially, and it's getting really, really hard to catch. But if you like, we've all gotten the phone calls where it sounds
Mhm.
like a real human,
Oh yeah.
but remember the software is only written to key on certain responses, and so you can confuse it by not speaking clearly.
Yeah.
Instead of saying hello, I always go, huh? And it doesn't know what to do. It doesn't know how to process that response because there's no logic in the software for that response. So it'll ask the question again and again and again. And then you could get it in this endless loop where it can't get itself out. I find that enjoyable because if they're wasting my time, they're not going to
Oh,
go and find an actual victim to prey on. So I just let it get in this loop and I just sort of mess with it till I get to where I'm going and hang up the phone.
and
Um,
that's what I do. I love just wasting their time for hours if I can. But because for me, the time that they're wasting with me is time that they're not hitting some senior citizen who doesn't know any better.
yeah.
So I absolutely love it. And yeah, I mean, this AI stuff is insane. The more I see about it, the more I hear about it. I'm hearing about, like you said, there are students who are using it and they're not taking the time to make sure that they're looking over what they're submitting. But also back in the day before AI, they had people who professionally wrote papers for students quite a bit. You just had to have the money to do it. Now it's just free. So it's going to be popping up a lot more.
Yeah, yeah, and so one of the things is that we're trying to do at the institutional level is we're not going to be able to defeat it because as a law enforcement officer, you'll appreciate this. A
Mhm.
company would come out with what I refer to as the fuzz buster, the radar detector, Gen
Right.
2. Well, police don't have something that can receive this. 6 months later, they put out the LiDAR that can pick up that frequency.
Mm.
So, right. So you get a 6 month head start, and then here come the 5.0 behind you with the newest
Yeah.
technology. And then what do they do 6 months after that? They come out with a new one for the consumer. And then 6 months after that, they come out with a new response for law enforcement.
And that's how I explain a lot when folks ask about laws, and there are a lot of laws that should never even be on the books, but every law that's out there is primarily there because the crime is or the action has already happened that made that law necessary.
Yeah.
So when folks say, "Oh, that's a stupid law," why is that? Well, because someone actually did it somewhere.
Yeah.
And my best example is in the city of Detroit. They have on their ordinance a law that says you cannot walk your alligator in the city of Detroit unless you have it on a leash. And that's because some guy back in the 1930s had a pet alligator that he would walk around in Detroit and just let it walk right beside of him. And folks don't understand. Yeah, that may sound stupid, but somebody actually did this to cause this law to be here in the first place.
Yeah.
So,
I mean,
you know,
it's the same thing. Like, if you've ever seen the label on a hairdryer, do not use this while you're in
yeah,
the bathtub. The lawyers had to put that on there because somebody sued. And one, you go, well, who would use a hairdryer in a bathtub? Well, that sounds stupid. Well, remember, products liability law does not limit the liability only for what its intended purpose,
mhm,
but it expands it to the reasonably foreseeable purpose. Is it reasonably foreseeable that somebody who's running behind would be in the bathtub trying to dry their hair after they washed it? Yeah, that's reasonably foreseeable. It's not reasonably foreseeable that somebody is going to use a chainsaw as a toothpick.
yeah.
So I don't have to put a label on the chainsaw box. Don't use this to clean your teeth.
But
That's
this is
not a
also where the statement "Hold my beer and watch this" came from too.
yeah,
So,
exactly.
how many cases have you seen like that where somebody has done something so utterly stupid that it just dumbfounds you?
Um, so it's not always a case. Sometimes it's things within cases.
Okay.
Um, I had I had a family law case a long time ago when there was a court order that the parents of the child who were divorced could not have overnight partners with whom they were in a dedicated relationship when the child was present. So on the weekend or the night you don't have boyfriend, girlfriend, whoever come over, maybe you live together, but when the child comes, somebody has to go stay in a hotel, whatever. That's what the court order said. Well, my client was frustrated because their ex's significant other was cohabitating with the ex and was present with the child. They hired me, paid me money, go argue this case. Okay. Oh, by the way, I know that you have also spent the night with your significant other when you've had the child. I'm not going to ask you that question. It's going to come up on cross-examination. Just expect that we're going to get our teeth smashed in. And we got our teeth smashed in. It actually went a whole lot better than I could have hoped for.
Really?
But the legal term for that is latches, or the clean hands rule, right? I have to come to court with clean hands. If I'm saying they're violating the court order, I can't have also violated that same court order. It's not do as I say. It's not do as I say, not as I do. It's do as I say and as I do. You have to walk the walk if you want the judge, to make the other party talk the talk. That's the reality of it.
Oh yeah, another example I use that I really like is up until the last 10, 20 years that have passed. When you bought a new vehicle, it came with a manual that basically showed you how to take that vehicle apart and put it back together. Now it's more about, this system works this way and all that. And then you have the disclaimers. Do not drink motor oil. And, to me, it's amazing. But, folks, someone drank that motor oil at some point. It's like the woman who decided she was going to use Gorilla Glue in her hair and then was surprised she had a helmet she couldn't get off of her head and had to have surgery. Have you seen that?
I did see that. She made the news.
My God.
Well, I didn't know this was going to happen. I was just out of hairspray. What were you possibly considering the alternative outcome for this scenario to be? Because I really want to know this.
I saw that, and then I saw her trying to get it. I almost wet myself. It was just amazing. Now, I don't know if you know or not, but I understand that she actually brought litigation against Gorilla Glue over that. I was just wondering if you'd heard anything.
I hadn't followed up. It doesn't surprise me, but I don't know that I don't know that the suit would withstand a challenge, right? There are certain things that we just cannot disclaim away, right? The only thing that we have a duty to disclaim are really what we call latent hazards, and like latent fingerprints or fingerprints we can't see, so we have to dust and raise them with tape or whatever. Right? If it's a patent or patent patent hazard, we don't have to give you warning. Like, I shouldn't have to warn you that your fingers are going to stick together. There's a reason. The instructions say, if you've ever read them, do not use this unless you have gloves on. Make sure you put on rubber or plastic, some sort of protective glove when using this. So it's when you accidentally drop super glue on you, you don't stick your palms together. You don't look like the guys from Home Alone, like the bad guys from Home Alone with their hands glued together, right?
Or those protesters who glued themselves to the floors and then couldn't understand why it's still stuck there.
Yeah. So, and I tell people, I remind them, when you buy a ticket to the Taylor Swift Eras Tour, when you buy a ticket to a Detroit Tigers baseball game, when you buy a ticket to Six Flags Over Texas, you are buying a license. That license is a conditional, it's a conditional admission to the park or to the event. Just because you bought a ticket to the Detroit Lions baseball game doesn't mean you get to go hang out in the clubhouse and eat the food and drink the beer. You don't get to do that. Just because you bought a ticket to the Taylor Swift concert doesn't mean you get to grab her on stage, right? There are limits to that license. And if you abuse that license, there's language on the back of the ticket. There's language on the end user license agreement that says, I agree when you buy the ticket. That says, this is a limited license. If you don't follow our protocol, whether we put it on the back of the ticket, we put it on the website, we put it on the billboard, or we tell you face to face, if you violate a rule, our security guards dressed in bright yellow will grab you one under each arm and haul your fat, happy butt out to the parking lot so you can listen to it from outside.
Yeah, and that is actually a great segue into one of the questions that was presented when we first started. And folks, if you have a question, please put it in all caps, question, and then take your caps lock off. That way I know it's a question or a comment that you have. But Veronica, Grant Cardone is suing a venue because his $700,000 watch was stolen off his wrist. The venue states, "Not our problem." Thoughts?
Yeah, same reason you can't you can't sue the city of New Orleans when you get pickpocketed during Mardi Gras. If you were dumb enough to wear a $500,000 watch out in public, you deserve to have it lifted by somebody smarter than you.
Exactly. And you couldn't have said it. I couldn't have said it any better. That's, what are you, what in the world? $700,000 watch?
Well,
Man,
I've
come on.
I've done some videos on Grant Cardone, but I'm not going to
Mhm.
get into it here.
Yeah.
Hey, and for I don't know how many we've got watching, but guys, if you haven't, make sure you like and subscribe to Poe on the
Yeah.
Go.
And
For
they
my viewers, and if you haven't
always.
subscribed to mine, hit the like and subscribe button as well. It does help drive the algorithm. I know I'm on my way to 10,000. He's rapidly approaching 5. So if you haven't,
Yeah.
make sure you go like and subscribe to his channel.
Yeah, we just cleared 4 and it was great. And Goldie's been really good about making sure that she's putting the link in there for your channel and everyone. If you all know who Zac is, so if you haven't, get over there, give him that like, give him the subscribe to his channel. I mean, he's putting out great content. And I think that, anytime where we have content like this, it only helps to make life better for everyone, period. Because there's a lot of things that we have questions about that we don't know, but here are some places where you might actually get some insight into how it actually works or what the reasoning is, or it just might educate you.
Yeah,
So
I've got some shorts up. I'm going to add some more, 2-minute videos about, or I guess there's some not they're not quite a short, a little longer. Landlord tenant law. You're moving into an apartment or a rental house. What has to work when you move in? What do you do if it doesn't work? Maybe you've got kids and you travel, or you're a single parent and something happens. Do you have a release prepared for somebody to take over the welfare of your children in your absence? Right? If you're going to travel and your flight gets delayed, you don't get back in time, and somebody has to take your kid to the doctor, they need a release to do it. They can't just show up with your kid.
I mean, it's, and I think one of the biggest problems with a lot of people is ignorance of the law. They see social media, things like that, and they go, well, it says this in this article or that. The law can sometimes be completely different than what someone's personal opinion of what it's going to be. And that's why I always say, if someone has a legal question or something like that, you need to contact an attorney.
Yep.
I was a cop. I knew about criminal from the police side of it, not from any civil liabilities or anything like that. And I don't even try to get into those.
And please understand, a lawyer is not Reddit. It's not your best friend at the bar.
Right.
It's not your neighbor. Get a referral from them. If they had a good experience with a lawyer or a bad experience, use that referral for information. Do not rely on Redditors who got liquored up and mouthy to tell you what your rights are, please.
Or SOV sites. Oh my gosh.
Yeah.
But and that's like with me, if I have a situation and I think there might be, say, civil into it, I call friends of mine who are attorneys and say, what attorney do you know that would handle this? And they'll tell me, I don't do this, but this is an attorney who's really good and they have a lot of experience. Here's an interesting question from a poet. He just published a collection of poems that are making fun of the Church of Scientology. Would they be able to bring an actual suit against him?
So the short answer is, in our system of pleading, yes. The question isn't can they sue, it's will they be successful.
Right.
And the only way I could reasonably foresee they would be successful is if it was not guised as poetry, but rather was guised as a statement of fact, which would give rise to defamation. But and on another video, I can't remember if it was by myself or with I was contributing or something, I can't remember exactly, but I talked about Larry Flint, Jerry Falwell versus Larry Flint, Hustler magazine.
That's a great one.
Right. In the use of parody, a statement of fact that is clearly parody is not defamation. So depending on the nature of the content, theoretically, it could possibly be defamatory. But if it is clearly in jest or satirical or hypocritical, if it's clearly used as comedy or something like that, then it certainly wouldn't withstand judicial scrutiny of a defamation case. So I would be surprised if they have anything to worry about. But I also tell people, the odds of you getting sued by the church are very slim. If they bring a lawsuit, they open themselves up to discovery, and they cannot withstand the scrutiny of discovery. Especially the Keebler King Chief Elf himself cannot withstand the scrutiny of discovery. That's why They've sued people all the way up into the early 90s, and then they quit after they got their butts handed to them royally.
And
After that,
very,
they've never
yeah.
sued anybody.
And that's an excellent point on that, is that they used to be this huge monster of litigation, and it suddenly died and you didn't hear any more of it. And I think that's an excellent point, of the fact of, through discovery and through the different processes, how much information they have to put out, how much Keebler King himself is going to have to be brought into it, and what he might have to face when he has to sit in front of a judge. So it'll be interesting to see what goes on with Leah Remini's case that she's got going on. That's going to be pretty monumental.
She is what I refer to as the perfect plaintiff. She's likable. She's relatable. She can afford to not settle. I mean, the reason the church has always gotten away with it is they just write a check that you can't afford not to cash.
Well, remember the Monsanto cases back in the 90s, early 2000s?
Yeah.
I personally know a gentleman who owned a company where they literally separated the seeds from the product. Mm-hmm. And a lot of farmers who weren't using the Monsanto products were then turning around. They were being sued. And the whole point of it was to get them into discovery, where they could actually ask them, who are your clients? And then they were going after their clients from that point. And this guy, he had a family business, had been in operation for over 60 years. He had to shut it down.
Yeah.
So here's an interesting question from Stephen Britton. Does defamation need actual measurable damages, or can something be defamatory if it meets other criteria? Be untrue.
I think that's actually IE.
Okay.
Such as be untrue. So there doesn't have to be, there doesn't necessarily have to be damage, although there is a damage component to it. The only one that expressly does not have to have damage is what we call libel or really defamation per se, which is an untrue statement about certain subjects. For example, about certain topics. For example, somebody has certain diseases, which are traditionally STDs or venereal diseases, which is untrue. That they are an adulterer, specifically as to women, because the law was written by men for several hundred years in this country, specifically to women, that a woman is of loose morality.
Right.
We high five the stud and we shame the woman. So we created legislation because that's what we did for years. And then that somebody is a thief at their job. For example, they steal from their employer or something, or that they have committed a crime, that they have committed criminal wrongdoing of misdemeanor speeding is not what I'm talking about. Murder or bank robbery or something. So if it falls into that category, there's no damage component. You just have to prove that they said it. You automatically win. The question is simply how much. But normally there does have to be a damage component. We saw this in the Johnny Depp trial. He had to prove that he missed out on a bunch of acting gigs. And so they hired a Hollywood expert that said, I've been in Hollywood for 50 years. And I can tell you, based on the people I've spoken to in these affidavits, Johnny Depp would have been cast for this role, except Johnny Depp would have been cast for this role, but for, we call it the but-for test, but for this statement, this person would have gotten the job. So there is inherently a damage element to it, but that's probably the least of the concerns, because I can simply say, my kid got kicked off the soccer team.
Well, here's an interesting question. I ran for state representative here in Michigan, and when everything went in and it was fully filed and all that, my opponent was saying some things that were provably untrue. When I talked to my attorney friends, they said, you put yourself into the public specter, and they may be untrue, but you're not going to win any kind of case for defamation if we could even bring one against them for it.
That's correct. So that's the New York Times versus Sullivan standard. New York Times versus Sullivan created the public person rule, what's called the actual malice rule. If you are a public person, there's two types of, or public figure. There's three types of figures. There is a non-public figure, which is just average Joe neighbor. There are public figures, the Kardashians, famous athletes, famous actors. They want to be famous. They choose to be famous. And then there are limited public figures. So I always think of Kim Davis, the conservative court clerk from Kentucky who refused to grant gay marriage licenses.
Oh, yeah.
After the strike down of DOMA, right? After gay marriage it wasn't legalized, but the ban was unconstitutional. So it basically it allowed it to happen across all 50 states. She refused to grant gay marriage applications. Her intent was not to be famous. Whether I agree with her or disagree with her, she claims it was religious. Now, we're not going to talk about the fact she had like 6 husbands or something, but that's a different issue. Yeah. But the reality is she didn't choose to be famous. She got that way. So she's a limited public figure. She's a limited public figure as it pertains to this issue. Maybe not where she goes to church. Maybe not that that she's got to drink and probably not, she doesn't, but family, whatever. She's a limited public figure only for this one issue. And I haven't met her. I'm sure she's a nice lady. I have no independent knowledge of this person. She became a limited public figure. New York Times versus Sullivan says, if you are a public figure or a limited public figure, and you sue someone for defamation in your capacity as a public figure, you have to prove actual malice, meaning that the statement maker knew that what they said was true, or they had reckless disregard for the truth of the statement. Essentially, they were saying the New York Times made defame me, and the New York Times said, we did our due diligence. We had it on good faith from multiple sources that this statement was true. Wow. And the court has said that when it's especially as it pertains to like politicians who are choosing to be public figures, they're putting their name on TV, they're putting their name on the ballot so people can get to know them and say, this person represents my values and ideals, so I want them to represent my interest in government. Wow. If you become a public figure, and you sue somebody, you have to show actual malice, because the courts have said that part of democracy is creating discourse and creating discussion by making allegations that may be demonstrably untrue, but perhaps it plants a seed of discourse. It plants a seed of questioning of the government, which is exactly what the framers considered when they created First Amendment protection. So that's the advice you were given from your lawyer. That's why you were given it. He was used in the New York Times versus Sullivan standard.
Excellent. Thank you. And that goes right along with how he explained it, except he was a little more along the lines of the city attorney knocking me on the head going, hey, dummy, you're the one who got yourself in this situation. Now you got to deal with it. Here's a good question from Friezino. What exactly does it mean when a lawyer asks to treat a witness as a hostile? And what does it mean?
So a hostile witness is a witness that traditionally I call in my case in chief, but on direct examination. Direct examination does not allow me to ask leading questions, right? I can say, what is your name? You say, my name is John. Do you run a YouTube channel? Yes. What is the name of your YouTube channel, right? Yes or no questions. Leading questions are, you would agree with me that exceeding the speed limit is unlawful, true? Yes. Right? A leading question suggests the answer in the question.
Okay.
Right. It is not true that you were on time. You were in fact tardy, were you not? Right. So the question suggests an answer. That's much more confrontational. That is traditionally only allowed on cross-examination. But sometimes I actually did this in a case. I called a witness to testify. They were just a jerk, and they were going to make it clear to everybody that they felt like they shouldn't have to be in court answering questions. They hadn't been sued. They weren't even a party to the suit. They were just a witness who had material information that I needed to extract from them. They showed up, they crossed their arms, and what is your name? Well, I'm not going to tell you. Well, why does it matter? Okay, cool. Judge, can I treat him hostile? Yeah. Your name's John, isn't it? Yeah. And you work in the construction industry, don't you? Right. I ask them these leading questions, and it helps move it along. And it also, the judge in most hostile, and not all, but some judges will give an instruction in various jurisdictions to the jury. This, right, because the jury's job is to evaluate how believable or not believable a witness is. That is absolutely something the jury can consider, is whether or not this person got hostile and was treated hostilely. Excellent. And maybe it could simply be that this is a freaking wild card that I can't control through direct, but I can't call him in the case. I can't call him in the other case, the other side's case, to get him on a cross-examination perspective. I need to cross-examine him now, but he is just out to lunch crazy. I'm going to treat him as a hostile witness just so I can shape the testimony and move us along. So there's a variety of reasons, but ultimately the short answer is, when somebody treats a witness as a hostile witness, it means that on direct examination, they get the approval from the judge to ask them leading questions as part of the examination. That's all it means.
And I think that's another one where you see so much in media, the television, movies, things like that. Your Honor, permission to treat as a hostile witness, but they never really explain, the actual rules to it or why it comes to that. Alex has an interesting one. How do class actions work in the US? What sorts of things could be valid class action cases against, well, he's saying Scientology, and how many people then it from suit to class action? So I think he's asking
Yeah.
basically like the building blocks of what you need to have a class action and how many people you would be a basis to start
Yeah.
with.
So the qualification for a class action is that you have to have a nominal, what we call a nominal plaintiff, which is the class representative suffered this harm. And in the working, we don't just get, if you call me tomorrow for a lawsuit, I don't just go to the courthouse tomorrow. I have to do all of my research and make sure that it's a valid case before I file anything. During my research for the case, I discovered that there were thousands, tens or dozens or hundreds or thousands or tens of thousands of people who suffered a common occurrence. And so we refer to that as the common nexus of interrelated facts. And that all of these people suffered the same damage or went through had the same situation happen to them. And therefore, rather than having to file 10,000 lawsuits, I file one lawsuit. And when it goes to jury, the jury is tasked with two things. First, to determine whether or not all the plaintiffs collectively win, or if all the plaintiffs collectively lose. If the plaintiffs collectively win, the jury then will award, and most of the time it's actually settled before that. The jury says, yes, you did it. Okay, now we can settle an award, and there's just a gross amount of money, a bulk amount of money set aside. The lawyers get their fee, and then they divide that amongst the number of plaintiffs. And so the most famous of these is probably the tobacco settlements from the 90s. This various states sued the tobacco industry because the tobacco products were known to cause cancer and other diseases and illnesses. And poor people who were on Medicaid, the government was paying for cancer treatment. The government was paying for all of these the tobacco and smoking related diseases and illnesses. And the tobacco industry knew about it, but basically refused to do anything about it. So the tobacco industry said, we are going to settle with you. And Oklahoma actually has what we call the constitutional lockbox, the Oklahoma Tobacco Settlement Endowment Trust, TSET. The however many hundreds of millions of dollars the state received went into that, and it's used for stop smoking campaigns. Right. So if you're a tobacco user in Oklahoma, you can call 1-800-QUIT now. They'll send you free lozenges. They'll send you free gum. They'll send you free patches. They'll get you with counselors, all kinds of support. If you want to stop using tobacco, that you can do it completely free.
That's awesome.
That money is a percentage of it goes into Common Ed, the K to 12 education system to provide additional funding there as well. Education and some of those is key, not just to society, but also to educate on some of these harms. And every year, the tobacco industry, as long as they continue to sell cigarettes or any tobacco product in Oklahoma, continue to pay several $1 million a year into that settlement trust.
Wow.
And so a lot of states took it as a one-time, look at all this extra money we have. Oklahoma said, we're actually going to lock this up and make it basically last in perpetuity. It's endowed just like an endowed professorship at a college or an endowed scholarship where the money pays for itself every year on the interest. That's exactly what they've done. And so they represented all of the states. The class action was the 50 states. They all had thousands or tens of thousands, in some cases, citizens who were on Medicaid, which is a state level provided health care for low income, who were suffering from tobacco related illnesses. And they said the tobacco company has to pay for it. But I can't find every Oklahoman who died of a smoking related or tobacco related illness who was also on Medicaid. There's just too many of them to figure out. So we're just going to take a gross amount of money and settle it. And we're going to just pay it out, distribute it across all the victims. That's how class action works.
Let's remember, and this is early back in the 50s and 60s, they were telling you smoking will help you out. It will ease your anxiety, things like that.
It was marketed to women to lose weight.
Yeah. It was insane, the marketing. From Alex, Scientology is trademarked. Selling a t-shirt with Scientology is not allowed. However, someone starts a blog called Scientology Business. Can I print and sell a t-shirt with the word Scientology on it?
So, Alex, I will refer you to I think since you're British, either a solicitor or barrister. I can't keep them straight. One of them goes.
And he's a ginger. Remember that.
I would refer you to a legal expert in the UK as it pertains to trademark law. Generally speaking, there are certain fair use exceptions. This is not one of them. If you're using a trademark or you're using as a motivation a trademarked product, you need to change it a minimal amount. You have to change it 20% or 30%, whatever it is. You have to change it enough that it is clearly distinguishable from the trademark logo. And the classic example, if you look, where's my finger? If you look right here at the SPTV Universe logo, that is modeled after MTV. But the people who own MTV would likely lose a copyright or trademark infringement suit because it clearly has been modified. It's motivated and the inspiration comes from MTV, but no reasonable person could infer that to be MTV. The motivation, the inspiration came from it clearly, but it's been changed enough that you're not going to face any issues there. So that's actually a pretty good example of what you would have to do to use it. The use of the word at all is probably going to get you in trouble. So I would avoid the word completely. But if they had they've got their weird sort of cross with the asterisk and the star thing on top or whatever, you might be able to do something with that logo if you change it enough. But I would consult with a intellectual property specialist somewhere near where you live to figure out exactly what the laws where you are require, how much has to be changed in order to be in compliance.
And you also got, and I know personally some friends who've been involved in these kinds of cases. There's I believe the standard is 10% change, but that doesn't always work. I mean, if it's a big enough company with enough money, they can fight you to the ends of the earth on it. So, me personally, I'd stay clear of anything that could get me caught up in that. Let's see here. Jamie Lynn, Zach or Poe, are either of you worried about being fair gamed for being part of SPTV? It'd be truly dumb on their part if they tried, as it would only give Leah even more evidence. I don't know about you. I'm not afraid. I've already had an encounter with a private investigator, and I've had some pretty bad things said about me on the internet that were proven wrong. I don't care. They're not going to. I'm not the kind that backs down.
Yeah, it is what it is. It's what they do. If they do it, they do it. But they're okay. Whatever.
Yeah, and
I got more things in my life to worry about than some mouth breather fogging up the windows of a car, taking pictures of me walking in to teach class. Yeah,
I'm not. Yeah, I mean, and one of my things is when I actually talked to the PI that was dealing with me. He was talking about pulling my trash. I said, "Well, did you enjoy that?" And he goes, "Yeah, it was all dog poop." And I go, "Yep, that's exactly why Roscoe biscuits are in the trash. If anybody wants to pull my trash, you're going to have to fight through all that." And Manuel, no, I have never been given a reason as to why I'm not getting my super chats, even after they clear my content. But it's basically one of those things. It's a David Goliath. What am I going to do? There's not much I can do for it. That's why, and Zach gave me a great piece of advice. That's why I put the Amazon wish list on my description to my channel. And that's why I do the buy me a coffee, because I'm tired of giving YouTube money that they didn't earn. So
yeah, guys, you have all been fantastic about taking care of me on the Amazon wish list. So jump over to Poe on the Go's Amazon wish list, find something on there, pick up for him. Doesn't have to be big, just something to show your appreciation for and support. For those of you who aren't creators, this takes a significant amount of time to schedule these, to set them up, to build the outlines. It's more than just I enjoy doing it. It's more than just the conversation and the education. There's a lot of behind the scenes, right? Trying to schedule it around family events and all that kind of stuff. So whatever form that takes for you, find a way to support your creators. I do take super chats, but I tell the people on my channel, don't feel obligated to spend a nickel doing this. I did this before I was monetized. I'll continue to do it. Find a way to support creators, whatever that is. Maybe you get 10 of your friends to like and subscribe and it drives traffic. Maybe you pick something up, you buy a coffee, whatever it is. Find a way to support your creators. Whether that's super chat or any other way, there's 1,000 ways to support them. Find a way to support your creators.
And I've said it a million times on here, folks. If you can't do it, don't. I don't expect you to spend money you don't have.
Yeah.
I every dime that comes into this channel goes back into new cameras, new lights, new equipment. I don't spend any of it on me, so if you can't, don't do it. But if you can and you want to, please, find the other routes, because I'm tired of them taking people's hard-earned money. What is the weirdest case you've dealt with that you can talk about?
Sure. So I had a family law case in which I represented the grandparents in a guardianship. And I'd always heard the stories, but I'd never experienced it myself. But after the judge, so mom and dad were, I had the grandparents. They basically had the grandchild living with them, but they needed a court order that supported that because the grandchild was getting of the age where they needed to be in school. So you had to have the guardianship letters, and we needed to get birth certificates, social security cards, all the things that a guardian needs. Mom and dad were separated. Mom was pregnant by a different guy's baby. They were both struggling with, they were both substance abusers. One of them had relapsed. The other was struggling with substance abuse and trying to stay sober. The other was actively using. It was just a mess. Well, one parent, dad, agreed. Yep, I'm unfit. You do what you got to do. Well, mom, and I understand this, was not fit, but was fighting to keep her child. And after the judge said no, the child's going to go with the grandparents, I'm going to enter an emergency order of guardianship. I'm going to set this for a due process hearing in 30 days in accordance with statutes. We're going to come back and relitigate these issues, but everybody's going to have more notice. It's a whole thing. And she didn't want to give the kid up. So the deputies walk into the courtroom, and there's this pregnant mother on the floor screaming, holding a baby. The deputies are peeling arms off, and then grandpa swoops in and picks up the grandkid. And I said, you go to the jury room with him now. Just go. Take the kid, get behind the door of the jury room. I will get with you guys in a little bit and figure out what we're going to do next. Grandma's trying to put fires out. She's a fixer. That's what she does for a living. Yeah. And listen, I know what you're trying to do, but the best thing you can do is stop talking and go get in the jury room. Let the deputies handle her. But there's been enough trauma in this child's life already. We don't need to aggravate this. And it was sort of surreal because, I mean, in criminal court, if they're in custody, they're in belly chains and hobbles.
Right.
They can't go anywhere. They can get mouthy, but they're going to get a spit hood and shove it back in the holding room.
Mm-hmm.
But this is the first time This is the first time I've had to see law enforcement physically intervene. And it was just sort of surreal. Like, is this really happening? Because I've known this family for a long time. Is this really happening when the deputies are fighting this pregnant lady off, and then we're trying to get the baby taken care of and secured, and grandpa's got the baby and they're running to another room, and grandma's trying to put fires out, and okay, you need to leave. And then at the end of the day, it's just me, the judge, and two deputies all sort of looking at each other. And unfortunately, the judge says this happens a lot. Mm-hmm. Emotionally, that's taxing on the judge, because the judge has a legal obligation to act in the best interest of the child. And in this case, the best interest of that child be removed from the home and placed with grandparents.
I think family court is the most dangerous of them all. I've been there for the homicides, all that stuff, but family court, that always scared the crap out of me, because you never knew what was going to happen.
Family court, pro se, they're all irrational, but pro se litigants are irrationally dangerous. They don't have a lawyer sitting there saying, shut your mouth. If you don't you dare say a word. Their emotions get the best of them, and they come flying over tables. It's one of those things. There's no right or wrong. It's ugly no matter which way you do it.
Right. Oh yeah.
But and parts of that is hard for me to check at the door. Like, I get home, if that's the only thing on my docket that day, and that courthouse was 2 miles from my house, right? I live 2 miles from the courthouse. I got home. It's the only thing I did that day. I feel exhausted. I just want to go to bed. I want to take a shower, go to bed. Like, I feel dirty.
For me, it was rough. It was like you said, it's so emotionally draining when you had to deal with family matters. I've talked about it where we had 2 children. The daughter was 10 years old. The son was 7 years old. Mother was addicted, and she would leave them alone for days at a time and give them like $2 to $5 to buy food for the time that she was gone. Having to take those children from that home and turn them over to CPS, and just how much it destroyed them emotionally. It's one of those times I came home, put my head in my wife's lap, and just cried.
And I've seen moms who are trying so hard to do things right, but they just don't know how.
Yeah.
They were not raised in a stable home. They didn't learn any of the parenting skills.
Yeah.
They didn't learn any of the parenting skills, so they have no skills to convey. They're trying so hard, they just don't know what right is.
Yeah. And that's
right. And so in those cases, the best thing for the child is to go to a stable home with grandparents or an aunt or an uncle or whoever. So one, the child has stability, but two, the parents who in Oklahoma, unless there's an adoption, you're required to have a parental reunification plan. It's a set of guidelines that the court requires the parents complete before they can petition to get the child back. Right. For example, you have to submit in most courts in Oklahoma quarterly drug test results, follicle tests that are negative. You're subject to alcohol screening. You have to go to a psychologist, have a substance abuse panel done, and then comply with the recommendations of the therapist. You may have to go to anger management. You may have to, most places you have to show stable employment for a year and stable housing for a year. So to show that you're making improvements. In that case, the best thing for the child is to go to a home where there is stability, so that not only is the child stable, but the parents can learn how to parent. They can learn how to discipline. They can learn how to accommodate. They can learn how to raise children. They can learn how to negotiate. They understand they can understand the importance of routine. Right. And so if they, just as an example, right, I need somebody to be a good example and I can follow directions, but nobody's ever given me a roadmap. So we put the child in a situation where a roadmap can be developed, and then we allow the parents to learn. And when they feel like they've learned, then they could go back to the judge and say, Judge, here's all the wonderful things I've done. I've been through co-parenting through divorce classes. I go to all of the t-ball games or all of the soccer games or all of the, gymnastics meets or whatever it is. I go to all of these things. I'm having overnights with my child, and here's my pay stubs for the last 12 months. And here's my lease agreement for the last 12 months. So it's awful at the beginning. At the end, it's generally smiles and happy tears. But at the beginning, it was anger and violence and unhappy tears. So the start is often not pretty, but normally the conclusion is.
Oh yeah. And Stephen had a comment on here. It's pretty sad. Some people don't have instinctual parenting skills. Well, you take a young mother, 13 to 16 years old, has a child. She's raising the child on her own. She doesn't know what she's doing. And there are those who've never had parents in their life that would be considered good parents, or parents who would be role models for them as parents. And it's sad, but it's a true reality in this world. And sometimes those folks need that extra hand to help make them be the parent that they need to be. So,
yeah. So there's something called the ACE. The ACE test, if you haven't taken it, it's called the Adverse Childhood Experience Evaluation. I encourage everybody to take it. I learned a lot about my wife based on her ACE scores. And whether you grow up in a violent house, a neglectful house, a house with substance, whether you're exposed to substance, people who start, we know statistically people who begin drinking below the age of about 16 or 17 are like 250 times more likely, somewhere around in there, to develop an alcohol dependency. Right. Wow. So if you grow up with heavy drinkers or drug users, if you are a drinker or a drug user, especially when you're too young to do so, it alters brain chemistry. Right. And so although there is an instinct in most folks, a parenting instinct, that can be chemically changed. Or you can also be emotionally immature to the point that instinct did not fully develop because of the environment you were raised in. So if you haven't had the ACE, if you haven't ever taken the ACE exam, for the viewers out there, if you you can Google it, take it, fill it out. It's like a 10 or 15 question quiz. Fill it out, score it, and it'll tell you what the different numbers mean. It'll tell you how high your risk is for drug and alcohol dependency. There's all kinds of things based on the ACE score. So
yeah, there's a lot of online, I wouldn't call it tutorials, but a lot of online product that's free to you, that you can look into things that might help with some issues that you have, but never be afraid to reach out for help. And Stephen, yes, if there's a 13-year-old having a child, it's another issue going on as well, but it happens every day of the week, multiple times a day. It's not uncommon. Talking about the weirdest experiences I've ever had, we went to a domestic violence situation. We arrived and I walked in and it looked like someone had just taken a water balloon and popped it in blue red substance all over every wall. And I saw a guy sitting in a corner. and he literally had holes all over him. It looked like it had been a shotgun. And he started moaning, and I almost passed out because I thought he was dead. And in the next room, we hear someone else, and there's a woman in there in the exact same situation as him. We find out that she had been addicted and was expecting him to bring home his check and give it to her. It was the wife. When he came home, he's like, no, I took the check right to the bank because he knew what was going to happen to all their money if he gave her the check. She grabbed a 2x4 that had a gutter spike in it, which is a nail about 11 inches long, and began hitting him all over the place. And he took it from her and began hitting her back. And it just insane. I'd never seen anything like that. Two people just so destructive on each other. And they both ended up in prison for the, it's one thing to defend yourself, but after that, it's not defense anymore. That's why he ended up going to prison himself. So it's a crazy world we live in. And what people do to each other is just, it's horrific. And even for the most minuscule reasons, you'll see people doing things that are just out of horror movies or legend. So, but Zach, we're getting on to 2 hours here now. I know you've got your family is there with you, and I always try to get these closed about 2 hours if we go that long.
Yeah,
it's just been it's been such a wealth of knowledge coming out of this that I didn't want to stop it. But do you have any closing thoughts that you want to put out there?
Sure. So at some point in everybody's life, you're going to need an attorney.
Mm-hmm.
It doesn't matter. Like if you're getting ready, if you're opening a business, consult with an attorney. In Oklahoma, there's something like 14 different entity styles you can open a business under. Some are absolutely the right option. Some are remotely not the right option. And then, sometimes the differences are nuanced. If you get a contract, read the contract. If you don't understand every word in it, call an attorney. So don't be so all an attorney is. I refer to attorneys as plumbers. We fix problems. We just don't fix problems that are physical. We fix problems that exist
in the legal realm.
Yeah, in the legal realm. And take care of your business early. Like my wife has an executed medical advanced directive for healthcare. Ever since our oldest was born, we went into the hospital to have our oldest, and she had the paperwork filled out. Do not put your family in the situation to have to guess what you want.
Right, exactly.
Get with an attorney and fill that out, and please do not go to LegalZoom and find a document. Oklahoma recently overhauled twice in the last 4 years the durable power of attorney law, because they overhauled it, created an unintended consequence, and then had to go back and fix that, created another one. So don't try to go through this on your own just because you found it for $50 online. And if you ever see the sign, uncontested divorce is $50 in some person's yard, that's not a lawyer. That's a paralegal in the unauthorized practice of law. But unfortunately, the Bar Association can only regulate the practice of law from those who are licensed to do so. If somebody's unlicensed, the bar authority doesn't have jurisdiction to punish them. The criminal courts do, because it would be a criminal violation, but the DA's offices are full of other more pressing issues. So please, if you need help, go get a lawyer, talk to a bunch of them before you hire one, and don't sign anything without reading it. That's just a general rule for life.
Yes.
Like, you buy a new cell phone and you buy it on a finance plan, which you shouldn't do, but if that's what you have to do, I get it. Read every word of that, because by signing that agreement with AT&T, if you get behind in your cell phone, they have the right to sue you. But if they bill you wrong, you don't have the right to sue them under the AT&T contract of carriage. So, don't be afraid to call a lawyer. They are assets. They're not limited to the rich. There's a reason rich people use them, but they are not an asset of the rich. They are an asset that are available to the public.
Aren't there also a lot of programs where attorneys can work pro bono and then they're paid back through federal or state programs?
Yeah, there's grant opportunities. Some law firms the ideal lawyer would give 50 hours a year of free legal help. Every state, to my knowledge, has. In Oklahoma, we call it legal aid. Okay. It is a nonprofit, a corporation that provides legal services for those who qualify financially for them. And it can be landlord tenant, it could be divorce, it could be Even certain civil suits, and then even in large counties, when I was in law school, I used to work, I volunteered just so I could get FaceTime in front of judges and get to know people in the community. I volunteered for, my grandpa called it the old lady divorce program. It was the pro se waiver divorce docket. Those people who weren't represented by an attorney and their ex partner had either waived their appearance or was incarcerated or had moved away and they couldn't locate them or whatever, and they served them through notice in the newspaper, there would be an error with the paperwork. By law, judges can't fix that. That would be legal advice. So the judge would send them upstairs to the court, to the law library, to the clinic, and we would square all that paperwork away for them. We'd fix all those issues, go back in front of the judge, and we could often get it fixed same day and get them divorced within the hour.
That's awesome.
So there's tons of opportunities out there. Don't be scared by the fact that, I can't afford one. There are opportunities out there to find either free or reduced cost legal help.
And, there's a lot of stigma that goes with that. And folks think that if you go through some kind of channel like that, that you're just going to get somebody who failed in other areas as an attorney. And that's not true. A lot of times you're going to be getting new attorneys that are just loving doing this, or you're going to get veteran attorneys that they want to still be within the legal realm. And, don't think that because you're going through some kind of assistance program to have an attorney work with you, that it's going to be someone who doesn't know what they're doing. They're going to be qualified people.
Yeah. And Steve and Britton, I see you're, you make too much to qualify for financial based legal aid, but you don't make enough to pay for lawyers. So I'll tell you this, more and more lawyers are being encouraged because the data supports payment plans. Mm-hmm. A lawyer will actually earn more money from a payment plan. Like if I let you walk out the door because you don't have the cash up front to pay for it, that's business that I can't ever recapture. If I put you on a payment plan, I don't care if it's $25 a week, $50 a month, whatever. You just keep chipping away at it. It'll eventually get paid. And if at some point, for whatever reason, you just disappear, I still made more money than I would have if I hadn't signed you up as a client at all.
There you go.
So more and more law firms are accepting payment plans. I have a client right now on a payment plan. They're fixed income, and they pay so much a month towards the invoice. And then there's a point where we say, listen, we can't do any work for a while until you pay this down a little bit because the accounts receivable is fairly significant, but they'll pay it down, then I'll do more work. So I have clients on payment plans. So just because you don't have the cash in the bank to write one big fat check, find an attorney who will represent you on a payment plan. So yeah, there's options out there.
Yeah. And folks, I put the link for Zac's channel on there. I know Goldie has done it before. Make sure you get over there. You hit that like and subscribe. It is a fountain of information that you're going to learn. And, just like with everything else on YouTube, it's free. And it's there to help you, to help guide you, help get away from a lot of the stigma and things like that people hear about attorneys and courts and all that. Chad, wake up.
And
here he is. Chad, you got anything to say here, bud, before we close this out?
Oh, I had a lot of fun. I just want to say I agree. Do not go to court without a lawyer.
Exactly. I truly believe in that. And folks, that's the thing is that we do this, there was talk about the super chats and all that. But the fact is, I don't do it for that. I do it because I really enjoy this and I have a great time doing it. I get to meet great people like Zac and Chad, folks I never would have been able to meet any other way. And now, I'm able to talk to these folks freely and get to know them and know more about things that I've always wanted to know. So as a matter of fact, we've got to do something, Zac, about aviation because, I'm a nut for aviation.
That's one of the few things in the world that I'm really, really good at.
Excellent.
And guys, I want to invite the three of you, of course, or Poe and Chad. I want to invite you and the viewers as well. I'm approaching 7,800 subs. If I can get to 10,000 subs before I do an interview with my wife, we had some pregnancy and infancy loss in our lives. Okay. So October is pregnancy and infant loss awareness month. If I can get to 10,000 subs before I do that interview, we're going to do a fundraiser for a couple of organizations that support awareness and raise funds and provide research opportunities to reduce and eliminate pregnancy and infant loss. So, and if we have a 10,000 sub party, I want you guys to come on. We'll have a big time. We're going to give away some merch. We're going to have some guests on the channel. So I want to invite you guys to come on the channel when we do the 10,000 sub party with me.
And folks, and I completely mirror that. We've had loss in trying to build our family as well. So I know where Zach's coming from with that, and the toll that it takes on you. You know, I think that it's a testament to the love and to the relationship after something like that, because it could have completely destroyed us when it happened, but we used each other for strength. We leaned against each other. So, and you know, so that's another great reason. Get your hind ends over there and hit that like and subscribe on Zach's channel. I'm subscribed, and
So
I've
am
been
I.
watching the content quite a
I
bit.
appreciate you guys.
Oh yeah, we appreciate you. So folks, hopefully you've come out of this as I intended. You come out smarter, more educated, more aware, and more prepared for things that you may not know about, or you've just learned more about attorneys than you ever did in any other part of your life. And I appreciate each and every one of you for being here, giving me your precious time to be with us. And as always, life is short. You get one shot. Make it count.